Hey everybody, I'm Lis Wiehl, and I'm here for the next hour and a half. And I've got with me from Houston, Nicole DeBorde. Hey Nicole, great to have you with me.
Thanks for having me.
So it's been very fascinating. We've had Jason Van Dyke on the stand, and we've had the direct, the cross-examination, the redirect, and the recross. Now, it's all really been about in this direct and recross and cross of him about his perspective and the idea of what his perspective was in that fateful night in 2014 when he shot the 17-year-old. There's no question that it was he who shot him. 16 shots. You know, we've seen the video again and again and again, right, Nicole? I mean, it's so hard to see that. But Nicole, wouldn't you agree that really what is so key here in how it's being framed from the defense side or the prosecution side is his perspective that night, what it is he saw and what it is how he reacted?
Exactly. I mean, and that's what they have to show. They have to show from his point of view, was it reasonable to believe that this kind of force was necessary? So that's why they're spending so much time talking about what he was perceiving, how he was perceiving it, how he felt at the time, because that's really the key question. The jurors are going to have to decide whether or not, from his perspective, deadly force was appropriate.
Right. And what was so interesting to me is in cross-examination, the prosecutor really went in on some critical points that you really, and I know you were sitting there at home and you're analyzing this with me, she really went on, was it, you know, looking at that video, does it really make sense when you really piece that video down as she did? And as we watch it, does it really make sense, officer, that you would be opening your door and thinking that you would be able to stop the 17-year-old with your door opening that way and stop him with the door? And then we watch the video and have him stay on the stand. Yeah, I think that I would be able to stop him with the door. But, you know, when we're looking at home, we're saying, I don't think I could stop with the door at that point. No way. But we're looking at the video. The video is not shot, to be fair, from the officer's perspective, right? Again, perspective. So, you know, on recross, that a little bit of that came out, right?
Absolutely. And in this circumstance, videos can be a very difficult thing for both sides because, you know, obviously the video that we're seeing of him walking down the street is not the vantage point of the police officer who ultimately makes the decision to use deadly force. So, you know, he's watching this from a mirror potentially and partly out the side of his car. And that's a completely different thing. So being able to see what the jurors are seeing on the video really isn't instructive as to what he was feeling and thinking at the time that he made the decisions he made.
Yeah, well, the jurors don't think that make the decision. So I want to come back with you and talk a lot more about this perspective issue. I have a lot more questions to go back and forth with you on, but we'll do it on the other side of the break, so stay with us. We'll be right back. Nicole DeBorde with me. Nicole, let's getting back to the cross-examination here. Getting back to the issue of perspective that was so critical. At one point, the cross-examiner was going in about perspective, and she went on by hypotheticals. And Van Dyke got a little bit testy because she said, well, hypothetically, you didn't have to get out of your car. You know, you didn't have to do that. And she was trying to push him. And he said to her, you know, well, hypothetically, I didn't have to come to work today. And I thought, I mean, what was your reaction to that? I thought, I don't know, that might have crossed the line with the jury. I'm not sure that I would have been that flippant if I were the defendant on the stand for, you know, murder in this case.
Yeah, no, I think that was a bad call on the witness's part. I mean, this is what the defense attorney is hoping is not going to happen. It's just, you know, we're learning a lot about witness testimony over the last couple of weeks for sure, in general, but having a witness get angry or cross-examine the cross-examiner is usually for juries a terrible look. And it's generally not going to endear them to what you're trying to have them believe your perspective is. You know, and essentially when you're a police officer and you're accused of using deadly force inappropriately, you're effectively being accused of being a racist hothead. Right.
So the last thing you want to do is that. Hey, let's go back now to more Van Dyke testimony. We'll come back with you on the other side of that. But let's go right back now into the court live. Nicole, how surprised were you that he took the stand to begin with? I mean, that was, it's not often really that defendants take the stand in their own defense. Were you surprised in this case that he did?
I'm really not surprised, and I know that the defense team would definitely be aware well in advance that this video was going to be really a source of lots of cross-examination. Police officer defense witness is much different than what we see in general as defense attorneys. It's a whole different framework for starting out with credibility when you have a police officer defendant. And so right. I think they had to call him, and he had to want to testify to get this jury to believe that force was justified.
What about when in cross-examination again, because they really have to hone in on cross-examination, direct, kind of direct, I think the jurors know that, look, it's their guy, right? It's their lawyer. And of course, it's going to be nice to the defendant. It's, and it's going to, nothing going to happen. It's going to be a surprise. So I think the juries, the jurors are not dummies, and they know that in cross-examination, that's where the hard questions come. So what did you think in cross-examination where, the prosecutor said, what happened after that? After you were getting, that second, you weren't really done shooting after the first round. You were, what happened after that? And there was this moment of, he didn't want to say, well, I just killed a guy, and everything had changed almost. But he didn't really want to, even after all this time, sort of like, I don't know, confess isn't the right word, but sort of like have remorse. I didn't really see any remorse to it. Did you?
I felt like he, when he said, the guy wasn't moving anymore.
Right. He was dead.
He was not happy about it. But, it's an interesting thing because this is great territory for cross-examination on one of these cases for the prosecution, because you're asking the witness to parse out just a very few short seconds. And really, right. Your brain doesn't work that way. It's not how we perceive things. And so this witness is going to have no choice but to reinvent and guess what he may or may not have been thinking at that time. And that's dangerous for the witness.
Yeah. I just thought that was so interesting, because I would have thought that there's a fine line between overcoaching your witness, especially when it's a defendant. You don't want to have them seem overcoached. On the other hand, I thought that maybe a little bit more of contriteness and feeling, hey, whatever this is, whether it's legally, a legal conviction, whether it rises to that standard or not, there's a 17-year-old that's dead there, and there were 16 shots that were fired, and that video has been playing over and over and over again. We're going to come back to more of this, Nicole. We've got live, how we do it in Law&Crime. We've got lots of things going on. We've got that Texas case going that just started. We have that court, that case impaneled. This is now the third of the trial of this man. We know this it's been here we go. Here we are. It's a live case going on now. This case is now almost 25 years old, and we're going to go live to it now, and I'll give you a little bit more background as we start going live to it. But let's go back into the courtroom here live. Let's go listen to a couple more minutes of it, and then we'll come back. Nicole and I will analyze. But this case has been going on for now it's about 25 years, a little bit longer than that. Listen in. Okay, we're still on the Jason Van Dyke case, and I'm glad to have with me Nicole DeBorde. Nicole, you've been listening to all this, the cross-examination. It's gone back and forth. We're still so much on the question here of perspective. It's also been broadened out to, again, on what kind of what kind of protection that Van Dyke, felt that he had that day. In the form of, his other officers that were there, even in the form of his own car, was that going to be something that protected him or not? What was your feeling about, what he had in that, and also the feeling now that we've had with this this use of force expert that was on the stand? It came, interestingly enough, after his own testimony, after Van Dyke's testimony. Usually you'd think that you kind of end the defense with testimony of the defendant, but still we had another expert after that. How do you feel that went? How do you feel the strength of this expert coming after Van Dyke's testimony?
In this case, I think it makes sense to have the expert coming after the testimony of the person who ultimately used the force. And part of that is because the expert really needs to hear whether or not anything comes out in cross-examination or in the questioning in any way that changes the way that he is evaluating this use of force situation. So it does make sense that he testified after the defendant, and I think that he did a great job. I think that the questions related to all the other things that were going on around the police officer, besides in those few seconds when he actually makes the decision, are ancillary. And it's going to be up to the defense to really bring the focus back to those few seconds where the force was ultimately used.
Few seconds. Now we're talking about those 6 seconds. Remember those 6 seconds that were made so much of were in both his testimony, his primary testimony, when the cross-examination was saying, look, you had 6 whole seconds, 6 seconds to make a decision. And the cross-examination was trying to say those 6 seconds are a lot of time. You had a lot of time to sort of, you know, not back off, but to make an assessment that this really wasn't the use of force kind of thing, where the defense is saying, hey, it was only 6 seconds, right? Not enough time to evaluate that the victim here was not going to be, you know, so menacing. I mean, he was after all carrying a knife, which has been such a huge issue in this case.
Right, and the reality is that it is 6 seconds, but it's a fluid 6 seconds. The officer who's making the decision is making lots of decisions during this period of time. It's not like a test question where you're asked, you know, what would you do? And then you have 6 seconds to evaluate. What would you do? It's a series of thinking and decisions and evaluating. And so, you know, those seconds are being used up as he observes what's going on. So, you know, it's quick.
Right. Let's talk about the demonstration. What did you think of the demonstration of the use of force expert when he was asked by the defense to come off the stand, as he did, and was you know, meting out sort of the 12 to 14 feet, what it looked like. And then he said, you know, boom, how long would it take to react? And, you know, he went through this demonstration, of course, you know, getting the jury all, you know, wow, that was all it would take in that second to respond, and showing how quickly that time went, how quickly, you know, really bringing it to show that 12 to 14 feet is a very, you know, limited amount of space, and that the timing there is so limited when you think it was dark and all of the things that the officer was going through in his mind. This is what the defense wants to portray anyway. All the things he was thinking about, all the things that, you know, he had thought about when he was, you know, all the things. This is how he wants to portray it, the defense does anyway. How effective do you think that was from the defense perspective?
I think it was very effective. And the reality is that it's not just the body moving toward the officer or the officer having to engage physically with the suspect that's critical here. You know, I've taken these kinds of cases where, you know, officers have shot at people with knives into the grand jury before, and I've seen some of the questions that they ask. I've also taken a case in where a SWAT officer delayed in making the decision to discharge his weapon, and the person who was holding the knife 40 feet away threw it, and it landed right in the officer's head. Fortunately, that officer was fine, but it's not just physical contact. It's what can he do with this weapon in this space, and that's a short distance, and we're talking about a very, very small period of time during which very serious injury could happen.
Right, right. And we're also talking about 16 shots, though, too. So for the prosecution, I mean, they have that. Stay with us, Nicole, stay with us. We'll be right back on the other side, so stay with us. Well, Nicole, what we're seeing here, isn't it, when you have a case that's 25 years old and you've got a witness on the stand that's trying to remember things from that long ago, that, you know, witnesses, their memory changes, right? I mean, there's a big issue about this car. Was it a Monte Carlo? Was it a Caprice? I mean, these details are important, and now he's saying his memory has changed.
Right, and, you know, that's what we're finding out more and more about memory. You know, we once believed that memory was sort of this concrete stone tablet, sort of a recording of what we were seeing, and what we're learning over time is that memory is malleable. And how we think about things and, you know, other factors that we learn can affect the way we think we remember something.
Right. Well, here in this case, his cousin, this becomes very interesting. His cousin had the Monte Carlo, and so he thought that you know, his cousin, it was like his cousin's car. And in fact, he'd said to one of the victims, you know, one of the victims had said, "Oh, that's my cousin." And he said, "No, it's not. Look at the other parts of the car." And those things remain the same. He remembers those conversations, but the car itself is not. And that may become, I'm assuming, I don't know, but I'm assuming that the make of the car will become very important later in the case for the prosecution. And of course, now the defense will have a chance to say, wait a second, you said back, back in '93 that it was one make of the car. You can't now change it and say it was another make of the car just because you've got a, memory change all these years later. But he did say what has remained the same is certain things about the car, whereas not about the make of the car. So I'm assuming that the make of the car will become very important later on in the case, because what's happened here over the years is he was convicted. The crime happened in '93. He was convicted once and a mistrial another time. But then the mistrial was because he apparently confessed, but that confession was thrown out because it was coerced, the court said, by police. So we have the coercion. We've got one trial with the conviction, but that trial was coerced and the conviction was thrown out. So now that's why we're seeing a third trial 25 years later. So it's no surprise where you have a witness now on the stand who says, Monte Carlo, Caprice, I'm not sure. That's going to have a little befuddling of witnesses when you've got 25 years in between the crime and now a third trial. No befuddling here. Stay with us. We're going to go to a break, and we'll be seeing you in just a few minutes. Stay with us. We'll be right back. All right, so we've got the prosecution here, and this is a direct examination of a Mr. Hernandez. He was with another friend, Juan, and they were running away from the scene after they're being shot at with the two victims in this case, the victims who eventually die in this case. It's a double homicide case. And we've got the defendant here, Mr. Villegas, who's on this here, who is looking at spending the rest of his life in prison if convicted. Nicole, what do you think about this? I mean, this is the prosecution now really trying to lead a bit this Mr. Hernandez through the scene of 25 years ago, and so many things have changed. I mean, even the physical location in some ways have changed. I mean, the businesses have changed. The dumpster where they were hiding is no longer there. I mean, so many things have changed about the place. Isn't that hard for the prosecution?
Oh, this is very difficult for the prosecution. Not only do we have a unique situation where we have what would otherwise be a cold case. I mean, it's very, very old, which is always challenging. But to top that off, you have multiple transcripts of testimony in this case. So you have conflicting statements from every single witness that you're going to call in trial. And you pile on top of that all of this time that has passed, causing these witnesses to have difficulty with their own memories. So this is a little bit of a nightmare for the prosecution.
I know, but the prosecution is doing a valiant job, and Hernandez is still, feeling reverberations of it. He said, what it's like to be shot, you're kind of panicked, and you run, fight or flight. He was flying. Let's go to break now. We'll be back after break. Stay with us. All right, the prosecution's taking just a moment to look through some papers, it looks like, but what she's done right now with the witness is she's had him identify both of the victims in the case. She just showed him some pictures, not at the crime scene, just some pictures that he would have known the defendants from. So she's identified both the defendants for the record. Now it looks like all the lawyers are having a sidebar with the judge. Not sure what the purpose of this sidebar is, something and it's not even clear that the prosecution has called for it, but it looks like it's breaking up here fairly quickly. But really, for the record here now, both victims have been identified, and that's all that's important for here. But we will go to a quick break, and then we'll come back and have more. Oh, let's go back now to Nicole. What do you think is about Hernandez now, as far as what he's actually offering and so far in his testimony?
It sounds like they're just putting all of the old pieces back together to create this picture of what was happening at that time, and to talk about why he might not be remembering in detail some of the little facts. He's done what the prosecutor needs him to do, which is to identify the decedents in this case. So I think it's rocking right along smoothly, considering it's as old as it is.
Well, the prosecutor was very clear in making sure that, she really went down and said, you made this record in a cubicle, small space, at the time, shortly after. You signed it, here, even though it's not quite exactly your words. When you went through all of this, and you signed it. And wouldn't it be, we could all say that our memory is much better right after an incident. And of course, this incident would be emblazoned in your memory because you too were shot at, right? So if things were a little bit now fuzzy for you, you would certainly go with what the statement says at the time, right?
Exactly. That's what she's trying to establish, to make sure that whatever inconsistencies are brought up on cross-examination are sort of dealt with in advance by prepping the jury to hear possible lapses in memory.
Right. And what we don't know, and I'm just sort of thinking of this, and I don't know that it could happen, but it certainly might have. The defense could have dug something like this up. What if Hernandez has said something off the paper, so to speak, to friends, for example, over the course of 25 years, that the defense could bring up and say, Mr. Hernandez, didn't you speak to so-and-so and so-and-so, or conversations that you've had outside of the courtroom, and bring those in, and other people to say, well, Hernandez told me something else, and that could be brought in to refute what he said on this paper. But at least now the prosecution has had really wedded him to this paper that he signed after the fact. Wasn't this really sort of chilling when he made this sort of off-the-hand cuff statement? He said, while I was signing this, my beeper was going off, or the beeper of one of the decedents was going off in my pocket. Oh my gosh, it really brought it home for me.
Sure. No, those kinds of little details really personalize this story for the jurors who are, kind of putting themselves at the scene, putting themselves in the position that the witness was observing from. So, those kinds of things really do help paint a picture of what was happening.
Right. And as far as we know, Mr. Hernandez has no motive, against this defendant. And we don't know that he has any gripe against him, any motive other than, than this. Other than now, this is the guy that shot at him, right? All these years ago, this is the guy that, he was running with his other friend, Juan. Two of them got away, and two of them did not. But for this Hernandez being, a faster guy or in a better position, he would have been killed as well, he could be thinking. So there's a lot of stuff going on right now, I would think, with Mr. Hernandez.
Absolutely, and the prosecution's doing a good job of bringing us back in time and telling us, what exactly was going on that night.
Now, remember, though, those confessions that were gotten from the defendant here will not come out in this trial because they were deemed to have been coerced in that second trial. So those confessions that the prosecution had, they will not have in this trial. So they're not working with the same material, and they're also working with a case now that is much older. Fascinating to be really watching up for. So we're going to go to a break now, and we'll be back on the other side. All right? We'll see you soon.